In the past several decades, the U.S. tech industry has grown to immense power and influence. Combined, the top 6 U.S. tech companies by market capitalization make up a value of over $8.3 trillion. And together in 2021, they reported combined revenues of over $1.4 trillion. This is a flow of money comparable to the estimated annual GDP of countries like Brazil, Australia, or South Korea. Companies like Apple, Microsoft, Alphabet, Amazon, and Meta became so wealthy by creating platforms. That is, they created marketplaces which allow businesses to take part in the global internet-driven economy. Since these companies are in control of these platforms, they're able to take a cut of the revenues of the money that flows through them. For instance, Apple and Google receive 30% of all App Store revenues on their platforms. Of course, these tech companies are active participants on the platforms they create. Amazon provides an e-commerce platform that allows merchants to list their items, collect payment, and even handle order fulfillment from Amazon's warehouses. But Amazon also offers its own products through its own in-house labels like Amazon Basics. Many merchants feel that Amazon's in-house products have an unbeatable advantage because Amazon is in charge of deciding which products are shown and in what order when users search for products. And even if Amazon isn't using its power over the listings, which of course Amazon says that it doesn't prioritize its own products, so many sales go over Amazon's platform that Amazon knows which products are the best sellers. It can identify the most successful entries in a new product space and then rely on its network of manufacturing partners to develop competitors at a very low cost due to Amazon's economies of scale and vast logistics network. Then, even if it doesn't prioritize its own listings by having the algorithm rigged in its favor, Amazon still knows the inner workings of how that algorithm functions. It knows how to optimize a listing for ideal placement in a way that a third-party merchant can't possibly share. In this way, Amazon is able to use its control of the data and its knowledge of its algorithm to compete on the platform in a way that merchant partners can't. Apple is able to advantage itself on its platforms as well. Because Apple creates the hardware and the operating system, it can give its own apps privileged access to device capabilities that third-party applications just can't provide. Apple can also veto third-party apps that provide competing functionality to its own apps. So for instance, Apple does not allow web browser engines other than Safari on iOS. Although competing browser makers like Firefox and Brave appear on the App Store, Apple forbids them from actually using their own browser engines. That's why you can use Firefox add-ons on Android, but not on iOS, for instance. Under the hood, the iOS versions of these browsers are actually just wrappers around Apple's WebKit browser engine, which is built for their own browser, Safari. Given the role that technology plays in modern life and the modern economy, big tech has come under intense scrutiny by governments around the world. In the U.S., the power of large corporations is checked by antitrust regulation. However, attempts to apply this to big tech have been difficult. There are antitrust lawsuits in progress, for instance, by the Federal Trade Commission against Facebook, but these will take many years to resolve, and it's not clear at all that tech companies have actually violated existing antitrust law. After all, these laws were drafted over 100 years ago, long before anyone could anticipate the internet or the specific structures of corporate power that it would create. And that brings us to the subject of today's video, the American Innovation and Choice Online Act, or AICOA, a bill that attempts to restrain the power of tech companies by limiting their ability to prefer their own products and services over third parties on their platform. AICOA has 3 very important parts. The first is a definition of a covered platform, which is a new regulatory term used to identify very large tech platforms that would be subject to AICOA's rules. Second, it defines the list of 10 kinds of activities that covered platforms would now be forbidden from engaging in. Third, it establishes severe penalties for covered platforms who break these rules. Now let's go through each of those. The first thing is, let's talk about what a covered platform is. Think of it as being like a legal definition for a big tech platform, or at least big enough that the government is concerned about the platform owner's ability to unfairly position itself in the market relative to its competitors. This is a different strategy from existing antitrust law, which focuses on conduct by monopolies that unreasonably restrains free trade. In other words, to bring an antitrust action, one generally has to show that a company has attained market dominance and has abused this position to squash its competitors. AICOA's language doesn't focus on market dominance. Instead, AICOA defines covered platforms as those meeting certain requirements. And to explain how this works, we're going to go through those requirements one at a time and see whether Facebook would qualify as a covered platform. And spoilers, of course Facebook qualifies. Facebook is obviously exactly the kind of platform Congress is seeking to target here. So there are basically three parts to classifying something as a covered platform. Part 1, it has to be an online platform. Part 2, it has to be extremely big and important. And Part 3, it has to be extremely valuable. Now, those are my words. Those aren't the exact words from the bill, but I'm providing those here as nice top-level summaries before we dive into the specific terms here. Part 1 is we have to ask, is Facebook an online platform? AICOA says that platforms are websites, apps, or other online services. No problem. Facebook is obviously one of those. It's an online platform according to AICOA. Next, platforms let users upload content and see content from other people, or they facilitate sale of goods and services between users, or they have search features over a very large volume of information. Well, Facebook definitely lets users upload content and see content from other people, so Facebook satisfies Part 1. It's a platform. Part 2 says that a covered platform has to be really big and important. Again, not the bill's language, that's mine. What the bill actually says is that a covered platform has to have at least 50 million US-based monthly active users or 100,000 monthly active business users. Now I looked it up, and Statista says Facebook has about 263 million US-based monthly active users as of 2022, so they certainly meet that criteria. I'll call that being big. Now the other thing is it has to be important, or in the bill's language, it has to act as what it calls a critical trading partner. This means that it has to be able to restrict or impede a business's access to either its customers or some tool that it needs to actively serve its customers. Now, I don't have a business on Facebook. I don't know what that's like personally. But I hear business owners say that they pretty much have to be on Facebook because that's where their customers are. If Facebook kicks them off, then they lose access to their customers. I think that's what the bill is getting at when it defines critical trading partners. If you have the world's most popular, naked mole rat discussion forum, and it has 50 million monthly active users, it's not really a covered platform unless there are whole businesses whose livelihood depends on access to the vast naked mole rat community via your forum. So Facebook is a platform, which was Part 1, and it's extremely big and important, which is Part 2. But what about Part 3? It has to be extremely valuable. Again, extremely valuable is my term, and it loses a lot of the nuance in the actual language, but I'm trying to give you a summary, and extremely valuable seemed to be what this portion of the bill text was getting at. What the bill actually says is that the bill has to have either 1 billion monthly active users worldwide, not just in the US, or it has to be owned by a sufficiently rich company. Now, Facebook does claim to have over 1 billion monthly active users worldwide. So with that, they'd already be a covered platform. But let's say that they didn't. Let's say that Facebook actually only has 900 million users. This is where AICOA's language starts talking about the value of the company that controls the platform. And it uses different language for public and private companies. For publicly traded companies like Meta, AICOA looks for net annual sales over $550 million for 2 consecutive years. Or alternatively, they can have a market cap over $550 million for any 180-day period within the last 2 years. Well, Facebook is worth hundreds of billions of dollars, so it definitely qualifies here. Now, if Facebook were privately owned, AICOA looks for an annual EBITDA over $30 billion for 2 consecutive years. If you don't know what EBITDA is, that's okay. Just think of it as a way of measuring how much money a company took in before it paid its taxes and loans. All these dollar amounts are inflation adjusted. If you're sitting there thinking, gee, $550 million sounds like a lot right now, but after another few years of this inflation, maybe that'll be just enough to buy a sandwich. The bill drafters thought about that. And so these thresholds go up according to the Consumer Price Index. Finally, one important detail. AICOA doesn't look for ownership so much as it looks for control. Facebook is owned by Meta, but what if Meta sets up a private shell company to hold Facebook? What if Meta, through some convoluted accounting scheme, ensured that it doesn't have any direct ownership of that company, but it gets its profits and maybe directs how the platform is run? Well, AICOA's drafters were apparently very concerned about this. As long as Meta has at least 25% interest in Facebook, or exercises substantial control over its operations, or gets to appoint its board of directors, or meets a variety of other criteria that would suggest that Meta is really in control of Facebook, then AICOA defines Meta as being in control, and Meta's finances can be used as the basis of determining Facebook's covered platform status. Now, all of that is really confusing. But you can see what Congress is trying to do here. They're trying to pin regulations on tech giants and the companies they acquire while sparing smaller independent companies. They want something that is going to let them pin rules to giants like Meta or Alphabet and Apple while letting smaller sites continue unhindered. So that's why they're doing 3 parts to the definition of a covered platform. It has to be a platform, it has to be extremely important and big, and it has to be extremely valuable. Now I want to look at an example that I find really interesting. Let's look at Twitter and how it stands today in May of 2022. Are they a covered platform? Well, Twitter is definitely an online platform. It's definitely extremely big, and it definitely has enough users. And I'm sure there are plenty of businesses that would be greatly hindered if they were kicked off or shadow banned on Twitter. So it's extremely important. So that's parts 1 and 2 satisfied. For part 3, Twitter reports fewer than 1 billion monthly active users, but it is a publicly traded company with a market cap of tens of billions of dollars, which easily satisfies the financial requirement. So it is extremely valuable. I think Twitter would be definitely considered a covered platform today. But Twitter is in the process of being acquired by Elon Musk, who intends to take it private. Twitter's EBITDA for 2021 was $546 million, which is far below the $30 billion required for privately held companies. So if Elon Musk buys Twitter, it might not actually qualify as a covered platform anymore. Unless, of course, AICOA passes before the acquisition finalizes and the FTC and the DOJ categorize Twitter as a covered platform before it went private. In that case, it would remain covered until Elon could convince the FTC and DOJ to reverse their ruling, even if it changes ownership. So what would that look like? Well, AICOA provides that if a designated covered platform no longer meets the criteria, the operator of that platform can submit a request to the FTC or the DOJ to have the designation removed, and a determination has to be made within 120 days. Otherwise, in general, covered platform designations last for 7 years. Without that kind of appeal process, without asking the government to remove that designation, the covered platform designation lasts for 7 years. Now, it doesn't mean that at the end of the 7 years, the App Store or Facebook wouldn't be covered anymore. It just means that the government has to come back at least every 7 years and show that those platforms still meet the criteria and redesignate them. Okay, that was a lot of discussion about who is a covered platform. But what are the actual regulations that would be imposed on these covered platforms? Well, there's 10 things. 10 things you can't do if you're a covered platform. And just about all of them are variations on a theme. Companies owning covered platforms can't use their position to get an advantage over any of the businesses that use the platform. As is really customary with legal writing, the verbiage here is really wordy and tough for me to parse out conversationally. So again, I'm going to paraphrase. I really encourage you to click through the link in the description to the bill text, scroll down to the actual language here. If you want a head start on that, Control F and search for unlawful conduct and look for the part where unlawful conduct appears as a section heading. And that's the start of the section that defines these 10 rules. The first thing a covered platform owner can't do is give preferential treatment to their own stuff compared to that of, their business users. Or at least they can't do that in a way that hurts competition. The second thing is owners can't limit the ability of business users to compete against them on their platform. Third thing, owners can't selectively enforce their terms of service so that they let things slide for some businesses that they would permit for others. Fourth thing, owners can't restrict business users from using the same platform, OS, hardware, or software features that they use for their own services. Fourth, owners can't restrict business users from using the same platform, OS, hardware, or software features that they use for their own services. Fifth, owners can't make people buy unrelated goods or services or get access or preferred status on the platform. Sixth, owners can't use the non-public data they collect from business users to help them sell competing products or services. Seventh, owners can't restrict access of business users to the data they or their own customers generate on the platform or take measures to stop them from exporting that data off the platform entirely. Eighth, owners can't impede people from uninstalling pre-installed apps or from changing default settings that point people towards their preferred products. A carve-out here is that anything that's necessary for the security of the platform or to stop data from being exported to the Chinese government or foreign adversaries is still permitted. By the way, I've glossed over this, but the whole text of AICOA is full of these little clauses that pretty much say that none of the protections being offered extend to users affiliated with the government of the People's Republic of China or foreign adversaries. Ninth thing that covered platform owners can't do is they can't treat their own stuff more favorably than that of third parties in any part of their UI. And the bill specifically includes search results here. 10th, and finally, platform operators can't retaliate against users for raising concerns with law enforcement regarding any actual or potential violations of state or federal law. Now, that's a lot of stuff, and it's hard to understand what the full implications of that are. The verbiage here is really broadly worded, and I think it's safe to say that the consequences of that are going to be really far-reaching. I think it's safe to say that Apple and Facebook and Amazon and Microsoft and Google, they're all going to have to really change how their platforms work if AICOA passes. So for instance, Apple relies heavily on end-to-end integrations of its hardware, OS, and applications to deliver, the iPhone experience. Their apps have always been allowed to access features that no one else gets to play with. AICOA might stop that. In some cases, this would probably mean that some capabilities would get opened up to third parties. AICOA might motivate Apple to allow non-WebKit browsers on their platform. Maybe even AICOA means that Apple has to allow third-party app stores. Now, the downside here is that, by creating such liabilities for adding functionality for themselves without adding it for other people, Apple might just decide it's safer not to add the functionality in the first place. Maybe even they would have to take away existing functionality because it would be better and safer for them not to have it at all than to make it available to everybody. And this is because, not just that Apple doesn't want to compete, although that may very well be true. It's also true that creating third-party APIs is really difficult because those have to be documented and maintained and secured. It creates all kinds of stakeholders that get affected when you make OS changes. This really complicates the process of maintaining a platform. And it's really not clear how deep these cuts are going to go. Maybe Apple does have to allow that third-party app store, but, would they also have to let users run their own operating system on an iPhone? Would they have to let users replace parts of iOS to offer competing products like lock screens or launchers? It's really hard to say. And how far does that go? What about Find My? Apple has what amounts to a massive decentralized network of tracking devices. How much access to that do they need to provide to third parties? And for stuff like that, where there could be severe privacy or safety issues, covered platform owners have what's called an affirmative defense. Now, normally in U.S. courts, one is considered innocent until proven guilty. An affirmative defense works the opposite. A form of conduct is considered unlawful unless defendants can prove that they met certain lawful criteria. So, for instance, it's normally illegal to kill somebody, but self-defense is an affirmative defense. If you can prove that you are acting in self-defense, then killing somebody is not necessarily illegal. AICOA offers owners several forms of affirmative defense. If a platform owner's conduct is needed to prevent a violation of state or federal law, or to protect user safety or privacy, or the security of the platform, or enhance the core value of the platform, then it's not unlawful. Also, it's an affirmative defense to show that breaking these rules didn't actually hurt competition. Now, it's really hard to guess what this all means. Some critics say that Google Maps is an example of something that AICOA might forbid. Because Google Search is the dominant search engine on the web, it has over 90% of search queries worldwide. It presents all kinds of data from all kinds of web services on its search results. A court might find that the entirety of a Google search page is part of the platform. And Google pulls in data from sites like Wikipedia and dictionaries to put helpful answers above its search results. Frequently, that data comes from Google's own products like Google Maps. Critics say that Google would probably not want to invent Maps now because they couldn't integrate it with search results without also creating a third-party ecosystem whereby other map engines would be included on equal footing with Google's. It's hard to make sense of what that might look like. And even if Google can say that Maps is something that they needed to do to enhance the core value of their platform, that's an affirmative defense. It would actually have to go and argue this against the presumption that their conduct was unlawful. And if Google loses that case, the damages that they would suffer from a court judgment could be severe, possibly to the point where it would end the entire company. And that's because AICOA has very big, sharp teeth. Penalties for non-compliance are severe. Owners can be fined up to 15% of their total revenue for the period of time that they were in non-compliance. And the government's burden of proof in an AICOA action is preponderance of the evidence. In other words, the government doesn't have to show beyond a reasonable doubt that a covered platform operator violated one of the 10 rules. It just has to show that a violation probably occurred. If it can show that that violation probably occurred, then the only hope for the platform operator is to show evidence that their violation was covered by one of those affirmative defenses. So, to take an example, suppose AICOA passed tomorrow. Its restrictions would take 1 year to become binding. Imagine that during that time, the FTC classified the App Store as a covered platform. Then suppose that immediately after the restrictions became binding, the FTC sues Apple for some aspect of iOS, like allowing its own applications to have greater access to device capabilities like the microphone or CPU while their apps are in the background. After an additional 2 years of litigation, because these lawsuits always take a long time, suppose that the FTC wins. Court could fine Apple for 15% of its total revenue for the 2 years it was in noncompliance. If Apple's revenues were the same as they were in 2021 for each of those years, it would have to pay almost $110 billion. By comparison, Apple took in a net income of $94 billion in 2021, and they have $51 billion in cash on hand. So a $110 billion judgment could be fatal to Apple. If that weren't enough, repeat offenders can also have their CEO or corporate officers fined for their full compensation for the 12 months before and after a suit is filed. Since these hefty penalties could effectively amount to a corporate death sentence, it's likely that classification as a covered platform could itself spell doom for a platform. And those affected may be forced to amputate a great deal of functionality and cease development of new features. Faced with the possibility of such steep penalties for noncompliance, a covered platform designation may instantly reduce the valuation of a company like Meta. And perhaps that's exactly the idea. The mass consolidation of the tech industry has produced titans like the world has never seen. Of the 10 most valuable companies in the world, 6 operate platforms that would almost certainly be considered covered platforms under AICOA, and 5 of those companies are based in the United States. Their outsized influence on public discourse and commerce is felt every day and has been a persistent threat in recent years to more traditional power holders like those in government and established media. Little wonder, then, that the most powerful governments in the world, like the United States and the European Union, are considering increasingly stringent legislation to limit the power of these platforms and their owners. This has been a CipherSuite briefing. I'm Jonas. If you enjoyed this video, please make sure to like, subscribe, and share, and leave a comment below. Besides making sure that you'll see the latest content, this will also help the channel grow. Thank you very much.